A 90-pound, 14-year-old boy sits in an electric chair built for grown men. The leather straps don't fit his small frame. Prison guards have to place a book under him so he can reach properly. When they flip the switch and 2400 volts surge through his body, the oversized mask slips from his face, revealing the tears streaming from his frightened eyes. This isn't a scene from a horror movie. This is the true story of George Stinney Jr., and what happened to him on June 16, 1944, represents one of the most horrific miscarriages of justice in American history. But here's what will shock you even more. George's story isn't unique, and by the end of this video, you'll understand why his case proves that the death penalty is not just flawed, but fundamentally incompatible with justice itself. Let me take you back to 1944, to the small mill town of Alcolu, South Carolina. It's a place where railroad tracks don't just divide the town geographically, they divide it racially. White families live on one side, black families on the other. George Stinney Jr. was born on October 21, 1929, into this segregated world. At 14, he stood just 5 feet 1 inch tall and weighed between 90 and 95 pounds. He lived in a small company house with his father, George Sr., who worked at the local sawmill, his mother, Aimee Brown Stinney, his 12-year-old brother, Charles, and his sisters, Catherine, 10, and Aimee, 7. George was just a regular kid in a working-class family, living in a world where the color of your skin determined not just where you lived, but whether you'd receive justice when you needed it most. On March 23, 1944, 2 young white females went missing. 11-year-old Betty June Binnicker and 8-year-old Mary Emma Thames had been riding their bicycles looking for flowers, specifically maypops, the local name for passion flowers. The girls had been seen passing by the Stinney family property, where they briefly stopped to ask George and his younger sister Aimee if they knew where to find these flowers. Neither George nor his sister knew, and the girls quickly moved on. When the girls failed to return home that evening, a search party was organized. George's father joined the search effort, and George himself casually mentioned to another searcher that he had seen the girls earlier in the day. It was an innocent comment that would seal his fate. The next morning, a pastor's son discovered the bodies of both girls in a shallow ditch on the African-American side of town. They had been brutally beaten with what the medical examiner described as a blunt instrument with a round head about the size of a hammer. Both girls had suffered severe blunt force trauma that penetrated their skulls. The medical examiner found no evidence of sexual assault on the younger girl, though there was slight bruising on the older girl's genitalia. Within hours of the bodies being discovered, George Stinney Jr. was arrested. Think about that timeline. In less than 24 hours, police had supposedly solved a double murder and identified their suspect. No investigation, no evidence gathering, no consideration of other possibilities. Just a 14-year-old black boy who had admitted to seeing the victims. According to Deputy H.S. Newman's handwritten statement, George confessed to the murders and led officers to a hidden piece of iron about 15 inches long. But here's the crucial detail. There was no written record of this confession, no signed statement, no recording, just the word of white police officers in 1944 South Carolina. The arrest had immediate and devastating consequences for the entire Stinney family. George's father was fired from his job at the sawmill the very next day. The family was forced to evacuate their company housing immediately. They fled town, fearing for their lives, and they were right to be afraid. On March 26th, just 3 days after George's arrest, a white mob attempted to lynch him. They failed only because he had already been moved to a jail in Columbia, 50 miles away. For 81 days, George Stinney Jr. sat alone in a jail cell. He was questioned without his parents present. He had no attorney. He was completely isolated from his family, who weren't allowed to see him until after his trial and conviction. Imagine being 14 years old, torn from your family, accused of a horrific crime you didn't commit, with no one to advocate for you, no one to comfort you, no one to even explain what was happening. This wasn't just cruel, it was a violation of basic human rights. But in 1944, those rights didn't extend to black children in the Jim Crow South. On April 24, 1944, George Stinney Jr. faced what can only be described as a legal lynching. The entire proceeding, jury selection, trial, and sentencing, took place in a single day. His court-appointed attorney was Charles Plowden, a tax commissioner who was campaigning for local office and had no experience defending capital cases. More than 1,000 white spectators packed the courthouse. Not a single black person was allowed inside. George faced an all-white jury, standard practice in the Jim Crow South, where African Americans were systematically excluded from jury service. The prosecution's case was shockingly thin. They called just 3 witnesses beyond the police officers: the reverend who found the bodies and 2 doctors who performed the post-mortem examination. The only evidence against George was the testimony of 3 police officers claiming he had confessed. No physical evidence, no witnesses to the crime, no motive, just the alleged confession of a terrified 14-year-old boy. George's attorney, Charles Plowden, mounted no defense whatsoever. He called no witnesses. He didn't cross-examine the prosecution's witnesses. He didn't challenge the confession or question how it was obtained. He didn't request a change of venue despite the obvious prejudice in the community. He didn't even ask for additional time to prepare the case. The trial lasted 2.5 hours. The all-white jury deliberated for less than 10 minutes before returning a guilty verdict. Judge Philip H. Stoll immediately sentenced George Stinney Jr. to death by electrocution. 10 minutes. That's how long it took 12 white men to decide that a 14-year-old black boy should die. Despite pleas for clemency from George's family, churches, and the NAACP, many coming from white women who were horrified at the prospect of executing someone so young, Governor Olin D. Johnston refused to commute the sentence. On June 16, 1944, George Stinney Jr. was led to South Carolina's electric chair. At 90 pounds, he was so small that the adult-sized straps didn't fit properly. Guards had to place a book on the seat so he could reach the electrodes. When they placed the execution mask over his face, it was too large and slipped when the electricity hit his body, exposing his tear-filled eyes to the witnesses. George Stinney Jr. became the youngest person executed in the United States in the 20th century. He was 14 years old. For 70 years, George Stinney Jr. was remembered as a child killer. But in 2004, efforts began to clear his name. His surviving siblings, now elderly, had never stopped maintaining his innocence. They remembered that day clearly. George had been with his sister Aimee when the girls asked about the flowers, and he had been home with family when the murders occurred. In 2014, after a 2-day hearing that included testimony from George's surviving siblings and forensic experts, Circuit Judge Carmen Mullen formally vacated his conviction. In her ruling, she found that George had been fundamentally deprived of due process throughout the proceedings against him. She determined that the alleged confession simply cannot be said to be known and voluntary, that his court-appointed attorney did little to nothing to defend him, and that his representation was the essence of being ineffective. Judge Mullen concluded, "I can think of no greater injustice." But here's what makes George Stinney's story even more tragic. He wasn't alone. His case represents a pattern of wrongful executions that continues to this day, proving that our justice system is fundamentally incapable of avoiding the ultimate mistake. Take Cameron Todd Willingham, executed in Texas in 2004 for allegedly setting a fire that killed his 3 young daughters. Like George, Willingham maintained his innocence until the end. Like George, he was convicted on flawed evidence. In this case, arson investigation techniques that have since been completely debunked by fire science experts. The Innocence Project assembled 5 of the nation's leading arson experts who issued a 48-page report finding that none of the scientific analysis used to convict Willingham was valid. Yet he was executed anyway. According to the Death Penalty Information Center, since 1973, at least 200 people who were wrongly convicted and sentenced to death in the U.S. have been exonerated. That's 1 exoneration for every 8 executions. Think about those odds. If you were facing surgery and your doctor told you there was a 1 in 8 chance they'd operate on the wrong organ, would you proceed? A study published in the Proceedings of the National Academy of Sciences estimated that at least 4% of people on death row are likely innocent. With over 2,400 people currently on death row in America, that means approximately 96 innocent people are waiting to be executed right now. This brings us to the fundamental problem with the death penalty: uncertainty. In every other area of criminal justice, we can correct our mistakes. If someone is wrongfully imprisoned, we can release them, compensate them, and attempt to restore their life. But execution is final. There's no appeal from the grave, no DNA test that can bring back the dead, no judicial review that can restore a life wrongfully taken. Some argue that life imprisonment without parole is actually a worse punishment than death, that spending decades in a concrete cell, knowing you'll never be free, is a fate worse than execution. If that's true, then why do we need the death penalty at all? If life without parole is indeed worse, then it serves the same deterrent effect while preserving the possibility of correcting our inevitable mistakes. George Stinney's case also exposes the racial bias that has always plagued capital punishment in America. According to the Equal Justice Initiative, defendants who kill white victims are 3 times more likely to receive the death penalty than those who kill black victims. Since 1976, 43% of those executed have been black, despite black Americans comprising only 13% of the population. George Stinney was executed for allegedly killing 2 white girls. Would the outcome have been different if the victims had been black? I leave such questions to you, the viewer. Every aspect of George Stinney's case reveals systemic failures that persist today. Inadequate legal representation. George's attorney did nothing to defend him. Today, many death penalty defendants still receive inadequate counsel due to underfunded public defender systems. Coerced confessions. George's alleged confession was obtained from a terrified 14-year-old without parents or counsel present. False confessions remain a leading cause of wrongful convictions. Racial bias. George faced an all-white jury in a segregated courtroom. While overt segregation is gone, racial bias in jury selection and sentencing persists. Rush to judgment. George was tried and sentenced in a single day. The pressure to solve high-profile cases quickly still leads to wrongful convictions. Official misconduct. Police and prosecutors in George's case withheld evidence and may have fabricated testimony. Prosecutorial misconduct remains a significant problem in capital cases. Here's something that will chill you to the bone. There may have been an alternative suspect in George Stinney's case all along. In 2014, during the hearing to vacate his conviction, evidence emerged suggesting that the real killer might have been someone else entirely. George's sister Aimee testified that she remembered the day well because no white people came around to the black side of town, except for the potential killer. Somebody followed those girls and killed them, she told the court. While we may never know the identity of the real killer, what we do know is that George Stinney Jr. was innocent. An innocent child was executed because our system prioritized speed over accuracy, vengeance over justice, and racial prejudice over truth. This brings us to the heart of the matter. The death penalty is not just flawed in its application, it's morally indefensible in principle. When we execute someone, we're not just taking a life, we're making an irreversible decision based on an inherently fallible system. We're saying that we're willing to accept the execution of innocent people as the price of maintaining capital punishment. How many George Stinneys are acceptable? How many Cameron Todd Willinghams? How many innocent lives are we willing to sacrifice to preserve a punishment that doesn't deter crime, costs more than life imprisonment, and serves no purpose other than satisfying our desire for revenge? The rest of the developed world has already answered this question. The European Union has abolished the death penalty entirely. Canada eliminated it in 1998. Even countries with historically harsh justice systems, like South Korea and Kazakhstan, have moved away from capital punishment. The United States finds itself increasingly isolated, executing people alongside countries like Iran, Saudi Arabia, and China. Beyond the moral arguments, the death penalty is also a practical failure. Death penalty cases cost 2 to 10 times more than life imprisonment cases due to lengthy trials, mandatory appeals, and the specialized housing required for death row inmates. Since 1973, the United States has spent billions of dollars on a system that has executed over 1,500 people while exonerating 200 others, a 13% error rate that would be unacceptable in any other context. 23 states and the District of Columbia have already abolished the death penalty. Others have imposed moratoriums. The trend is clear. America is slowly moving away from state-sanctioned execution, but it's not happening fast enough. Every day the death penalty remains legal is another day we risk executing another George Stinney, another innocent child, another victim of our flawed system. George Stinney Jr. should have lived to see his 95th birthday this year. He should have had the chance to grow up, to fall in love, to have a family, to contribute to society. Instead, he died terrified and alone in an electric chair, condemned by a system that valued racial prejudice over truth, speed over accuracy, and vengeance over justice. His story is not just a tragedy from the past, it's a warning for the future. As long as we maintain the death penalty, we will continue to execute innocent people. The only way to prevent another George Stinney is to abolish capital punishment entirely. The question isn't whether our justice system will make mistakes, it's whether we're willing to make those mistakes irreversible. George Stinney Jr. paid the ultimate price for our system's failures. How many more innocent lives are we willing to sacrifice before we finally say enough? The execution of George Stinney Jr. represents everything wrong with the death penalty. Racial bias, inadequate representation, rush to judgment, and the irreversible nature of execution. His story, along with those of Cameron Todd Willingham and the 200 other exonerated death row inmates, proves that our system cannot be trusted with the power of life and death. The only way to ensure we never execute another innocent person is to abolish the death penalty entirely. Life imprisonment without parole serves the same protective function while preserving the possibility of correcting our inevitable mistakes. In a system built by humans, perfection is impossible, but irreversible punishment makes our imperfections deadly. George Stinney Jr. was failed by every institution that should have protected him. The police who coerced his confession, the attorney who refused to defend him, the jury that condemned him, the judge who sentenced him, and the governor who refused clemency. We cannot bring George back, but we can ensure that his death was not in vain by finally abolishing the punishment that killed him. What do you think? Should the United States join the rest of the developed world in abolishing the death penalty? Or do you believe it can be reformed to prevent future injustices? Share your thoughts in the comments below. I read every single one, and I'm genuinely curious about your perspective on this complex issue. And if this story moved you, please share it with others. George Stinney Jr.'s story deserves to be remembered, and his legacy should be the end of the system that killed him.